Welcome to the Grey Area, the podcast where we talk about things which are not always black and white, and that's what makes it so interesting. Today we're talking a bit about medical malpractice, complexities around it, but basically delving into the recent Supreme Court of Appeal landmark judgment.
Okay, so the case nods was TN on behalf of BN versus the MEC for Health in the Eastern Cape. It involved a minor child that suffered injuries at birth due to the negligence of the hospital, and the hospital has conceded that they were negligent. Due to the negligence, the child has cerebral palsy, cannot walk, talk, and is unfortunately blind.
Yeah.
That is so sad. And the mom, acting on behalf of the minor child who is now 11, has claimed a sum of approximately 35 million rand. The life expectancy of the child is up to 22.8 years. So she's claimed from birth, probably for past medical expenses. The majority of the claim is for future medical expenses, which is in the sum of 30 million rand. As we said, the merits were conceded. The hospital admitted that they were negligent, but the interesting part comes in how the damages were awarded in the High Court. Okay, so first it was awarded in the High Court, went on appeal to the SCA, and the SCA overruled the High Court's judgment. But I think that's before we get into that, maybe as a Medmal expert, you can break it down for us how a Medmal claim traditionally works.
So, in general, from an insurance point of view, you'd receive the notification or a letter of demand or a summons, and that's when we would get involved, assessing obviously policy response. And once that's clear, looking into the actual alleged negligence. The important thing is having that expert view or the expertise to actually navigate through the actual negligence part. Once that's ascertained, we then go into looking at the quantification of the claim, which would entail past, future, pain and suffering, and those type of damages. And we guided either by the quantum of damages, case law, and other important information, and also, more importantly, experts' reports. So that's how it's traditionally done. Have we ever made these bartering arrangements? No, not in that context. It's always been settled once and for all, in full and final settlement on a without prejudice basis.
So the difference as to how cases were handled traditionally versus what the High Court tried to do in this case is that if I had claimed 35 million, for instance, right? Yeah. You would give me a lump sum for past medical expenses, you would give me a lump sum for future medical expenses, and a lump sum for general damages.
Yeah.
And what was different in this case was that with regards to the future medical expenses, which I don't know, you can tell me, is that always the biggest part of the claim?
It's quite substantial in most cases. It can, depending on the severity of the injury, right? Now, in the case
let's say in CP babies, which the injury is always severe.
It's always quite severe, and those damages can be quite substantial.
Yes, I think in my experience, it's always the biggest part of the claim, the future medical expenses. And also, we need to distinguish that this is not happening in the private sector; it's happening in the public sector, right? And what the MEC for Health tried to do here was to, instead of giving a lump sum for future medical expenses, they wanted to provide the care as and when, or provide it in kind, as it stated.
Like a bartering type of thing.
So when you, rather than give you 35 million and say, please go forth and take care of the kid for however many years, when the child needs physiotherapy, when the child needs occupational therapy, when the child needs aids, seeing aids, hearing aids, those kind of things, you would actually have to go to a state institution and get that treatment, rather than being able to control it with your own funds.
And what's important to note about that judgment is that it shaved off 7 million rand of the award.
Okay.
And that's a substantial amount. For the child's life expectancy that you mentioned was quite substantial, and also given the treatment that this child is going to require. But I think also what it does, it erodes that autonomy of choice as to where you're going to get the treatment, and also the parent's choice as to where to take the child. And I think a lot of people, or the judge in the Supreme Court of Appeal, took the view that there was that inequality between a child receiving treatment in a public facility as opposed to a child receiving treatment in a private facility.
So let's break that down. Would we say that private healthcare in South Africa is superior to public healthcare? Or are they just differences?
I think there would be differences, right? I think in this specific case, if you notice that specific region, there seems to be a higher amount of medical negligence cases.
Yes, exactly.
Right.
I would say
So
that,
it would be an unfair
I think we
assertion.
said in a previous episode that there were 3 billion. What did you say now? How many billion?
I think it's 120 billion
120
in
billion.
contingent liabilities.
Yes, contingent liabilities.
And
Yes.
I remember from the High Court judgment in this matter, what the economist stated, that there was an amount of 3.4 billion rand into the value of claims settled from a period of 2014 to 2021. So that was a substantial chunk of their budget.
Yeah, and that's for various factors. It can't just, I mean, we know that majority of academics work in public institutions, right? But there's also a problem of volume, because there's so many patients in a public, and not to make any excuses, it's not an excuse, but that's just the reality of the public healthcare system in South Africa, that the hospitals are overflooded. There's lack of resources, there's lack of there's a lack of medication, to I guess, to some extent. But I mean, I think you do get a quality offering in a public hospital, not to say no. Yeah, but you're right, the 120 billion is a huge number.
It's a huge number, and like you touched on, getting quality care. You could get quality care, but look at this, there was this interesting statistic I read, right? Only 16 from expatica.com. 16% of South Africans have medical aid.
Oh,
right?
really?
Yeah, which leaves the balance of people either not having medical aid, and that makes you wonder, and it's not to say that all of them can't afford private healthcare. Some of them will just opt to not pay what you would pay. So with private, again, you probably have access to more options in terms of treatments and also advancements of technology, but we can't just dismiss and fully pull down our public sector.
Yeah. Okay, so we're going down the rabbit hole of socioeconomics in South Africa now. So we'll get back to the judgment. Okay, so then the SCA also brought up the once and for all rule, and they also brought up that what else?
They also brought up the issue, like we mentioned earlier, about the attorneys, right? Because that should be something that should be regulated by the legal.
Okay, so the fact that the attorneys didn't set up a trust to administer the funds properly. And then the SA also said that the High Court was concerned about how the lump sums were being used.
Yeah.
But that's not enough to change the law of damages.
No.
And they also brought up the fact that that the law of damages needs to be changed by Parliament, not by the judiciary.
It's not a judiciary's function for them to do, and that also with the legislature, that's going to require a lot of consultation as well.
Exactly. I don't think you can make a change of this magnitude via precedent or via case law. You're right. There has to be a lot of consultation between not just 5 or 6 experts, but a whole panel.
A whole panel in different organizations, different stakeholders that have an interest in this matter as well. And I do get that the state was trying to use this as a test case so that they could see how they can reduce the financial constraint. Because they do always state that the claims are increasing faster than the resources available.
Yes.
And that has always been a huge bee in their bonnet, or something that has been quite something that they've struggled with. So I do feel that because there's this issue there, it needs to be looked at a wider level. And like you said, like the court ruled, the legislature would be the best place for that, because then there's that consultation. But it also calls for better risk management, or what is the cause or the root cause of the issue that's driving those claims to happen.
Yeah, I agree with you. And I don't think in the future there's absolutely no place for the law of damages to change,
evolve,
to
yeah.
evolve and to make it so that you can offer services in kind. But I mean, I think that the public needs to be 100% confident that
Yeah.
those services are going to be up to the standard that they require. And for that to happen, there needs to be procedures put in place. There needs
Yeah.
to be organizations that are specifically used for. I mean, it's not a small thing. There are so many medical malpractice claims against the state.
Yeah.
I don't think it would be a waste of resources to set up a place of care specifically for those people that are affected by the negligence. I don't know, Nats. What do you think
I
about
think
that?
there's definitely alternatives, because I know in the US and the UK they do have alternatives,
Yeah,
like structured payments and things like that,
yeah,
where they make interim payments as and when needed
yeah,
to cater for any kind of potential financial restraint. But it requires that in-depth discussion, because you do need to see who are the ones that are impacted by this. And also it calls for, like I mentioned earlier, better risk management and getting to the root cause.
But that's opening up a whole new can of worms. I
Mm.
mean, for medical negligence claims to get to the point that it is right now, I'm not just talking state, I'm talking private as
Across
well.
the board.
Across the board.
Yeah, it's a
I
concern.
mean, surely there should have been some risk management put into place to avoid it, but it seems to just the situation just seems to be deteriorating.
To some extent, you could say that, right? It just depends where. I think nowadays for example, a lot of institutions that have had these higher claims
Yeah,
are putting in these mechanisms. They are trying to be more proactive in trying to manage that risk. Also, the service providers and partners that they partner up with, we're holding everybody to account. But again, I think it's always going to be a thing where there's a lot of things that always fuels these claims.
I agree with that, Nats. I see where you're going with that. You're going to say that people are more now aware of their rights. That's why they're claiming more. Hey?
You read my mind.
I read your mind. I know you too well now. So, but at the end of the day, you have a CP baby.
It's a life-changing event.
Exactly. Irrespective of whether they're ambulance chasers, you have to claim if you have a kid that is so badly affected or severely injured as a result of negligence. And the root cause is not, I don't think, factors around. The root cause in the case of medical malpractice claims is definitely negligence.
It's definitely
and risk management, well, the lack of risk management or the non-existence of risk management. And I think, I don't know to what extent, I mean, I've been involved with a lot of insurers, and medical malpractice is not my specialty. But really, all I ever hear about is informed consent, informed consent,
Yeah.
informed consent. I never ever see any measured or considered risk management actions that are put into place by insurance companies.
I think it needs to go deeper. You need to do a deeper analysis in terms of that actual risk management to know what you're actually dealing with. Because like you said, one CP baby claim is something that can just erode a limit.
Yeah.
And the damages are quite substantial. But I think there's a greater impact than just someone getting that financial remuneration. The life of someone has been changed, altered. And it's not just the life of this victim, but it's the life of the ones around them.
Of course.
That have to take the responsibility to ensure that that person or their child is being taken care of. So it's a wider consequence arising out of that negligence. And how they're going to do it, again, like you say, it goes down to risk management, but also maybe better training of staff, ensuring that you have staff that are adequately trained, that can render that quality service. It's not just about efficient service, it's quality service that's actually needed, that reasonable standard of care that's expected of a practitioner.
And a lot of the times it's not something that the doctor actually did wrong. It's just a lack of communication or a lack of awareness. I mean, it takes a team to deliver a baby at the end of the day, right? Especially when your resources are constrained in a state-owned entity. But there's a whole team that needs training. It's just not the doctor.
Something like this can't be centralized to just one person. Okay, you're the gynae, but you said the gynae works with a nurse, or he works with a midwife, or he works with someone else. someone filling in the hospital file. It's a whole chain of people
Yeah.
that needs to be in that training line to make sure that they are adequately skilled to render that reasonable care.
And I think back to the original point that it's only when the risk management that is effectively launched can you then think about reframing how damages are awarded.
Definitely, because I do think there's a kind of a disparity in where these losses are happening and how. And until they undertake those actual exercises, I think that's when you can have more meaningful discussions as to how you want to limit the risk or the exposure, or how do you want to deal with whatever settlements. But at the end of the day, whatever settlements needs to be fair and reasonable. You can't shortchange someone. That would just totally be unethical.
Yeah, I agree. But I do appreciate what they were trying to do.
Yeah, I mean it's a test case. It made people think about how these things should be handled, and maybe it was also something that left food for thought for insurers. How do they handle situations? Because I know, if anything, when it comes to these type of matters, is to make sure that at the time when you have a claim is to have the right expertise, to make sure you do your investigations up front, that you can get the quantification and the information that you need so that you can get the value of the claim instead of proceeding all the way to court.
My view at this point, Nadia, is that if you are still trying to shave off your claim at claim stage, you are trying to stuff a problem.
It's a low ball. Yeah,
you're trying to stuff
Yeah.
a huge problem into a small bag.
Yeah.
The only way to get Medmal claims down is to do a deep dive into what exactly is going wrong.
To where are you seeing the losses? What are the actual causes? Because if you don't do a gap analysis, if you don't know why, how are you going to then remediate?
You can't. I think at claim stage it's already too late. In the case of a CP baby, right, no judge, and this doesn't even take into account social inflation factors, no judge is going to lowball the parent of a CP baby. Even if you have proper substantiation, etc., it's not a nice situation.
Yeah, and you would be acting like in bad faith or unethical. I mean, think about the reputational consequences. And there's always been this sensitivity around these type of issues, because at the end of the day, it's a life that's been impaired, like critically.
Yeah.
So I think if anything we've learned from this judgment, it is something that insurers have to watch as well. It doesn't matter whether it's the public sector, private is impacted in its own way, and actuarial assessments are so important, and reserving is so important. But I think it's another reminder of how the common law principles are the backbone in terms of the damages. And it would take a lot more than just the case to actually change and reform that.
Yeah, I think the hesitancy from the court to reframe how damages are awarded is telling. And I think it brings in a huge uncertainty factor. You know, I think if the court can say, listen, here's a lump sum, and then you do, I mean, obviously it's based on actuarial calculations and a lot of scientific things, then the court feels at ease. But for the court to say, you know what, you go forward and find these services elsewhere, there's a level of discomfort because you don't know if this person is actually going to get the treatment that was awarded.
Yes, and that's a huge thing. Are they going to get the treatment they need?
Yes. Yeah.
Because that child would not have been in the position had it not been for that negligence.
Yeah.
And now they're in need of something. They need of that quality healthcare that can at least better their lives. Obviously not bring them back to the same position had this not happened, but something to better or improve.
Yes, or make them just more comfortable.
And that's so important. And I mean, that's what society needs. We need to ensure that we have these resources available. And it was very telling, but it's also a big message for insurers in terms of how they handle their matters as well. That yes, lump sums are here to stay until otherwise changed.
And I mean, in that lump sum as well, Nats, you get, it's just not the treatment that is included in there, right? Obviously, if you need to get to the treatment, you need the parents to be able to travel there, and you've got you know, you're not going to be able to travel via public transport because you've got a wheelchair and you've got a whole lot of apparatus that you have to take with you. So all those things are factored into your lump sum, and it's a very real concern for South African people. How am I going to get to where I'm going? I simply cannot afford to do it. And when you take away the lump sum, you actually take away that person's access to the treatment.
And that's basically a right enshrined in our constitution and our Bill of Rights.
Exactly.
So I think that's the biggest concern, because it's not just everyone that's just, you're not just living like 100 meters away from a hospital.
Yeah.
So that's a very valid point. It's a wider network of people that's impacted by the situation.
Exactly.
If you had any advice to give to insurers, what would you tell them?
If I had any advice to insurers, I would tell them, get your risk management in order. Don't sit on this, because you're going to be sitting, the private sector in a few years' time, in my estimation, is going to be sitting pretty close to where the state-owned hospitals are. Because as much as there's only 16 people that have access to medical aid, that number is growing and increasing as our economy is becoming more sophisticated. Do your due diligence in terms of what is going wrong in the Medmal space. What is going wrong? We need to know. And it's been years, but still nobody seems to know what the issue is. And there must be some type of issue. It would be interesting now to compare our medical malpractice, particularly in respect of CP babies, to medical malpractice stats across the globe. Have you ever done that?
No.
Oh.
But it would be interesting.
Yes, it would be interesting. So it would be interesting to see. Or, I mean, go to a country, or get the global stats, go to a country where you see that these incidences are low, and then see what risk management protocols they have in place at their hospitals. I mean, majority of the world operates in state-owned. The patients
predominantly
state-owned, right? Not everybody can afford private. So, but I mean, I don't know. There must be some place where it's not as severe as it is here in South Africa.
Yeah, it depends on certain countries and what their structures or policies are in place and what their regulations allow for. So it's definitely something that can be looked into, but I think it requires that deep dive.
It does. There should be a task team, and insurance companies should drive for this. And the state would also benefit from it. So it should be a partnership. Get your best doctors, get your best lawyers, get your best insurance people, and go and see what's going on. Go and see what other people are doing in the world and how they are making sure that these don't happen. Because we're thinking about it, unfortunately, in the wrong way. We're thinking about it, and I'm not saying in the wrong way, I'm saying in the not less human way. We're thinking about it in terms of how do you drive claim costs down, right?
From a financial
point of view. But at the end of the day, there's still that human aspect to it.
Something went wrong.
Something went wrong. One child's life, even if one child's life is ruined, it's one child too many, not.
I mean, 100%. I totally agree with you, and something needs to be done to understand. And it's, for example, it's like a cyber thing.
Yeah.
It's like, how are you going to know what happened unless you investigate?
Yeah.
And that's so important. And you need to then, once you understand what the issue is, then you can remediate or put in certain procedures and protocols so that you can avoid an incident like that.
And the data is there. You have so many claims that you can extract data for to see what went wrong. There must be something that you can do.
I think there's definitely, and I think, like you said, it speaks to partnerships, collaborations, everybody being open to see what it is, a collective effort to see what is the actual situation, what is driving these losses. Because the saddest thing is, like, remember when you mentioned in a previous episode how your gynae dropped you?
Yeah.
And the saddest thing is, if we don't have the expertise of a specialist case, because you can't get insurance, because nobody wants to practice because of all these losses. So it affects the bigger ecosystem in terms of any of us could be subjected to a situation like that. You know what I'm saying? So it's a wider societal impact that needs to be considered, but also something that needs to be done to rectify the situation.
Yeah.
So in essence, as we've discussed, lump sum damages are here to stay, but it's going to require a lot more for our law to evolve. And it's going to require partnership and collaboration and all voices to make some kind of meaningful change. So we look forward to seeing you in our next episode. Until then, bye.